Hi, this is Michael Cohen. I'm a Dallas estate and elder law attorney, and I am joined by my good friend of many years. We did our radio station together, radio show together on his radio station I'm at, KAAM. And so now we're doing kind of going the updated version. Now we're doing podcast by YouTube as well. So kind of going with the times, as they say.
We have to. We have no choice now. Everything is video driven and we need to be seen, not just heard, I understand.
Well, I guess so. The only problem is, as I've said on one of these podcasts before on the radio station, I was just a voice, and now, unfortunately, people see this radio face.
Yep.
So, anyway, here it is. Here we are again, and this today's topic, Don, is going to be, as I call it, I am not my sister's keeper. In this case, the situation were two brothers under their mom's power of attorney, gifted themselves $5.576 million. Mom had a large estate. And in this case, it was actually in Massachusetts. There were four children. Frances was the mom. She had four children, Frank and Tony, Chris, and Tracy. And mom must have been a difficult person because every single child at one point was estranged from mom. She had a large estate. She was totally estranged from Frank at the time of her death and for years. She was estranged from the daughter, Tracy, for, gosh, ever since she was a teenager. She was abused and not sexually. I mean, just language or whatever, and she just didn't talk to her for the longest period of time. And then there was off and on periods with the other two children, Tony and Chris. uh, at one point, she probably didn't have good relationships with all of them. So that kind of tells you there's probably something wrong with her more than there are with the kids. Well, um, so but in her, well, probably about 15 years or so before she died, she regained, when she needed a little bit more care around early 2000s. Tony and Chris came back into her life and were helped take care of her. She, but I mean, she was just older, and so they had a good relationship. But then, well, she thought that they were going to try to, and she had a will where the great majority of the estate would go to Tony and Chris.
Of course.
Well, and she didn't have relationships really with the other two kids. She was going to give something to Tracy, but it was just a nominal, comparatively speaking. Well, then um, she fell she was on the outs with them again because in her mind, according to Tracy, she they were trying to put her, saying that she lacked capacity, maybe put her in a nursing home. Now that was actually uh, Fern thought that, and so now she didn't have a relationship with Tony and Chris. And Tracy then pounced on this and said and badmouthed her brothers. And then mom did a new will. Now everything almost went to Tracy.
Oh,
And she was the executor and the fiduciary. Well, later that year, now we're talking like 2012, they came back into her life. And then mom was disappointed with Tracy. Well, this because Tracy's the only one that had grandchildren. The other three did not have children, and she wanted to see her grandchildren. So she said, and so now she changed her will again and her power of attorney.
what?
Now, on the power of attorney, it gave the authority. and the language was would give make gifts to donees who I would have given to, who I may have given to. She started then having some, she was, well, who knows exactly when her dementia started, because it could have been before that. I mean, she's changed her mind an awful lot. She had some, seems like weakness of the mind. Who knows if there was undue influence or not? Well, in 2013, uh, Tony and Chris were talking to mom, and mom said something to the effect like, well, I don't really care so much about gifts. She had like a $36 million estate. She had a large estate, a state that was taxable not only at the federal level, but at the state level. In some states like Massachusetts, there's state estate taxes and gift taxes, just like there are under the federal law, that's different rates and things like that. Texas, we're fortunate. We're not that high tax state that some of these other states like New York, or I
Oh,
don't know, you were from Pennsylvania originally. I have no idea what it was there.
it's not good. California, of course, is a nightmare.
Oh yeah, California is terrible. Uh, so, um, so they talked with a financial advisor and about how sometimes people are gifting and stuff like that. And this particularly became a problem right before the um, 2016 was going to be, there was a lot of talk that when, this is not to be political, as you may recall at the time, the estate tax limit was 5 million, and there were some threats during the Obama administration that it was going to be reduced to 1 million. Thus, there would be more estate taxes, and if you made gifts, it'd be it's a lot of times it's unified. There could be more gift taxes too. So anyway, when in 2013 when they talked with people, when they talked with mom, Tony and Chris with mom, Frances, she said, look, I'm old now. I'm like almost 90 years old here, or I'm already 90 years old, and I really just care about somebody taking care of me. I don't really care so much about the gifting thing, but I hate paying taxes. And so, and when it came to 2016, before the election between Clinton and Trump at the time, Hillary Clinton and Donald Trump, they decided to make this gift through the power of attorney that said, I'm giving myself $5.576 million. $5.576 million. Well, if mom dies in 2016 at age 94, and after the estate, there wasn't any contest of the estate. And the sister sued. They said, well, hey, this is self-dealing. There's no provision that says you could self-deal. And they're basically breaching their fiduciary duty to take care of the estate for the benefit of mom. Well, what did the court say? Well, they first said, we're looking into it and we're going to look at the uniform uniform law on property. And there you have to show that if there was something, that there was good intent basically and things like that, if it would just go in accordance with what mom would have wanted. And what they said, or what the court ruled, was, look, she talked about the fact that there's talk about less taxes. A lot of people were concerned about the estate tax limit going down in 2016. The It said do whatever type of gifts I would have made, and you were on the outs with her because you wouldn't let her mom see your grandchildren, your children. So, in a nutshell, we're going to let this fly because that's the relationship y'all had, and that's the Uniform Probate Code says you could do it under certain circumstances, and she didn't want to pay taxes. This reduced the estate or gift tax limits. So, and these were the people who were taking care of her at the time, and those were donees, so they allowed the self-dealing. Normally, you can't have self-dealing unless you specifically state that.
It almost sounds like what you're saying is that they punted.
They gave to themselves. The
Yeah,
court, are you talking about the court punning?
the court. Yeah,
Oh, yeah, maybe.
yeah.
Yeah, they allowed it. They said, okay, yeah, we're fine with this, because um, now see, it's interesting because like normally, let's say somebody, we talked a couple weeks ago we did a radio show on ladybird deeds, and if you do, can somebody do a ladybird deed with a financial power of attorney? Unless you specifically state that there's broad gift giving ability. And perhaps if you're going to deed to yourself, self dealing, then a title company, if you deed something to yourself, would say, hey, that's self dealing. We're just disregarding that immediately. So your financial power of attorney must be very broad. And a statutory general power of attorney that would not be sufficient to do broad gift giving. Nowadays, there's what they call hot powers, and you have to say broad gift giving, and you might say self-dealing, and most people don't have that. We often use that in connection with transfer planning for public benefits, because there's different strategies you could use. But still, this is kind of controversial because it's self-dealing, and you got better be careful because what is that really doing, and what's in the best interest of the one who signed the power of attorney to begin with? Should you be using that money on that person, not benefiting somebody else?
Right.
And so that's the self-dealing argument. But, um, Tracy lost on this one. Maybe she'll appeal too. I don't know. That was just decided earlier here this year in 2026. And so you never know what a court's going to do sometimes. But this is another example. You be careful you need to be clear. So I guess on any document, was that clear enough? Who are the donees I would have given to? How do I know who that would have been? I don't know. The
Right.
courts had to interpret that. And so, um, if you want to say broad gift giving and self-dealing, well, just say it. And so sometimes things are not clear.
Right. And that's also something I've learned thanks to you. And that is that you've got to be so clear about who's getting what and who's not getting what, to the point where I think sometimes you've even said you've got to make it clear that this person is not getting something or anything or this much or that much.
Yeah, I mean, a lot of times, well, first of all, and now you're talking about like in a will or trust, if you're going to give, sometimes you always have contest provisions. But let's say you say $10. Well, is that going to stop somebody from contesting?
Right.
No.
No.
So sometimes you have to put a certain dollar amount. Is there a God-given right to an inheritance? No.
Oh,
But people could contest. We've talked in years past about Charlie Pride, and we talked about, you know, Charles Manson's estate planning and all those. We go from one extreme, there. But the bottom line is that you can do whatever you want, and you have to be clear. Um, and Charles Manson's estate, actually, there was a question if there was a will at all. So it's a little bit different. But that's a different story if you're interested in that, well, we have a podcast on that from last year or the year before, whenever it was done. Anyway, usually there's a lot of times when things aren't totally clear, then that's when things are more likely to be litigated.
right. Whatever your situation is, though, it's complicated. Whether it's a ladybird deed, like we talked about a couple of shows ago, I'm not my sister's keeper, which is today's show and today's topic. It is. So attend Michael's next workshop so you can get the clarity that you need for your estate planning. And that is to just simply call Michael at 214-720-0102. It's 214-720-0102, or go to his website, which is dallaselderlawyer.com, dallaselderlawyer.com. Michael?
Yeah, the workshops are 2 hours. They're free. They vary. The one in May was on Tuesday. The ones often we do them on Saturdays. They're usually in the morning.
In person, of
And,
course,
oh,
not
in person, yeah,
not
they're
online.
all in person. This way, you get a better feel for everybody, and you get to hear the questions. If we did it by Zoom, some people are on mute. You just don't really get the feel of a live audience.
Right.
So anyway, yes, it's 2 hours. It's free. We never know what questions people are going to ask because every workshop we've done, um, there's been different questions. I never know. It could be
And I
about the
like
one big beautiful bill. It could be about anything.
I like that about you too, because I don't think in all the years I've known you, 15, 20 years now, you've ever used the phrase, three-word phrase, I don't know. You always stay on top of it. And if you don't know, you will find out for that individual almost immediately and for yourself, which I really appreciate. But I think rarely, if ever, you've ever used that phrase.
Well, luckily, we've known the answers to the questions. So,
Right. Exactly.
and so hopefully that'll continue. I hope. When the one thing that's, one of these things that's good about these podcasts that we do and the articles I write, and I've been doing them for, gosh, over 30 years now.
Oh,
When you do that, when you write the articles, it's kind of an example, and you just think about, so it's easier to tell people, oh, okay, what's the story here? What is the lesson to learn? Well, when we draft a power of attorney, what is the goals of the client? Now, in this case, I'm surprised that they didn't argue undue influence or lack of capacity or something like that. But apparently that wasn't the case. But I wonder about it. Did she, usually when we have a question on capacity, we require a doctor to sign an affidavit or sign something that they've examined the person and that they think that the person knew whatever it is that they were trying to do. So, because if I'm not sure, I'd rather have some professional make that determination generally. So, anyway, uh, but the good thing about these different things is when even if it's a fun story like on I don't know if this is considered a fun story or not. I guess if you're the daughter, it's not so fun. But it shows you the importance of how you draft it and how you need to be clear that says broad gift giving and there's self-dealing if that's what you want. And be careful though who you give it to because it could come back and bite you. So that gets into, like on anything, when you name somebody as a fiduciary, how do I trust thee? Let me count the ways.
exactly. Well said.
Yeah. Well, Don, thank you again as always. I appreciate it. If anybody wants to attend our next workshop, just call that 214-720-0102 number or sign up online at dallaselderlawyer.com. It's free, it's no obligation. Although if you do go to the free workshop, we do give you a free vision meeting as well. So you get 3 free hours of legal education without any cost or charge. I hope to see some of y'all there. Thank you. Take care.